Good afternoon. Happy Sunday. This is Chille. I don't know if he's lying to you or if he's just really stupid. He holds this quotation up here, and he says that, according to the trifold, actually, officer, the Pennsylvania versus Mims holding says that a prudent man must believe that I'm armed and presently dangerous, for you order me out of the car. And this is what he's holding up. Now, I know it's hard for you to read, but I'll show you where he's getting this information from. He's getting this information from right here. The stop and frisk in Terry was thus justified by the probability not only that the crime was about to be committed, but also that the crime would be likely to involve the use of weapons. The court confined its holding to situations in which the officer believes that the persons with whom he is dealing with may be armed and presently dangerous, and fears for his own or other safety. Such a situation was held to be present in Adams versus Williams, which involved a person who was reported to be carrying a concealed weapon. And so it looks like maybe he has a point. Now, the weird thing is that if you Google, can a cop order me out of the car, or do I have to get out of a car if a cop orders me to, you're going to get a whole bunch of advice from a whole bunch of attorneys from all across the United States, and they're all going to tell you basically the same thing. Yes, you have to get out. Now, some of them might preface it by saying, well, it has to be a lawful stop. You know, the officer has to have a reasonable suspicion for stopping you in your car before he can order you out of your vehicle. And awesome, that's awesome. But the determination of whether or not the stop is lawful is not made on the side of the road. It's made in court at a later date. So generally speaking, attorneys will say, yes, if a cop orders you out of the car, you got to get out of the car. But not Chille, and that's really weird. But he has this language in here, right? This is the part that he has highlighted in this right here. That's the part he highlighted. And so one might think that Chille has a point, except what he's highlighted is from the dissenting opinion by Justice Marshall. So the language that he cited, the specific quotation that he cited, does not appear in the majority opinion. Now, the majority opinion does talk about being armed and dangerous, but they're saying that once the stop has occurred and after the officer has ordered the person out, if the officer then sees the bulge in the jacket, can the officer then frisk somebody? And that's going to come down to the question of whether or not the officer has reasonable articulable suspicion supported by articulable facts that there is a firearm present. The bulge in the jacket in that case permitted the officer to conclude that Mims was armed and thus posed a serious and present danger to the safety of the argument. In these circumstances, any man of reasonable caution would have likely have conducted a pat-down. But that's after it. See, there remains the second question of the propriety of the search. Because they're talking about all of this up here. All of this is dealing with can we get him out of the car? Can we get him out of the car? And the answer to that question was yes, they can. And how do you know? Well, 20 years later, the court revisited the holding of Pennsylvania versus Mims. And they said, in this case, we consider whether the rule of Pennsylvania versus Mims that a police officer may, as a matter of course, order the driver out of a lawfully stopped car to exit his vehicle if that extends to the passengers as well. And we hold that it does. So the rule is that an officer may, as a matter of course, order the driver of a lawfully stopped vehicle to exit his vehicle. And that rule, that as a matter of course, just he could do it whenever he freaking wants to, that extends to the passengers. And if you look at the fact pattern in Pennsylvania versus Mims, there is no hint that the officer suspected that the passengers were dangerous to him, specifically dangerous to him. They were sweating. They were nervous. That's it. He ordered him out of the car. When Wilson exited the car, a quantity of crack cocaine fell to the ground. That's it. There you go. That's all it took. And, yeah. So yes, every attorney will tell you that the cops can order you out of the vehicle. Some of them might preface it with it has to be lawfully stopped. A lot of them will tell you it has to be lawfully stopped, but they'll say, just get out of the vehicle. Why make it harder on yourself? Why get dragged out of the vehicle only to find out later in court that, yes, the officers had reasonable suspicion for the stop? So anyway, there you go. Chille's dumb. He's wrong. He's citing a dissenting opinion. The clear weight of the evidence is against him. Can the cops order you out of the vehicle even if they don't suspect that you are armed? Absolutely. Absolutely they can, as long as they've lawfully stopped you. Thanks for watching. Have a great day.